Hello friends, welcome to the channel All in One for You. First of all, subscribe my channel for more English and Punjabi shorthand dictations. Today I am going to dictate you approximate 400 words with 80 word per minute speed dictation. So be ready, let's start.
It is also possible to adjourn the case to lean working days and ensure that the witnesses come on that day. It is a daily experience for many a litigant that come to court is turned away without being examined because the court does not find time to examine all the witnesses that are brought to court. In such a situation, it will be unfair that if a party does not bring witnesses on a particular hearing, he must lose the opportunity altogether. If the court is otherwise engaged, it ought not to make a big issue of the absence of a party and close the evidence once and for all. The stiff approach that the court employs in closing the evidence must be tempered with tactful judicial approaches to elicit the best of cooperation from the litigant and his lawyer and secure his presence at the appropriate time. In this case, the court did not employ appropriate resourceful approach. Suffice it to say to point out that if these ever be an occasion when the side is closed and a petition is filed for reopening the same, the court shall not normally dismiss the petition but shall consider giving an opportunity subject to appropriate terms as to costs except in extreme circumstances of manifest contumacious conduct or there is seen an attempt to harass the other side by deliberate delays. In Nagappa Vernaker versus Prabhakar SCC 410, while examining Order 18 Rule 17 CPC, the Supreme Court held that the provision could be invoked only in a situation to enable the court, while trying a suit, to clarify any doubts which it may have with regard to the evidence led by the parties. The provisions were not to be used to fill up omissions in the evidence of a witness who has already been examined. This provision was again examined in a different situation akin to the present situation in KK versus AIR SC 1000. In the case before Supreme Court, the application was moved after the conclusion of examination of witnesses and after the partial arguments were over. The court should award appropriate costs to the other party to compensate for the delay. If the application is found to be mischievous or frivolous, or to cover up negligence or lacuna, it should be rejected with heavy costs.